Very good evening, everyone. Welcome to today's Legit class organized by Legit Quest. Legit Quest is an artificial intelligence based legal research product. And Legit Quest has recently started with Legit I, which is news, interviews, and column. I'm Chahat, and I will be moderating today's session. Today's Legit class is on Amendment of Insolvency and Bankruptcy Code 2016, suspension of proceedings, need of the hour, or an overkill. We are honored to introduce our guest speakers for today. Our first speaker is Ms. Ruby Singh Ahuja. Ms. Ahuja is a senior partner with Karanjawala Co and an advocate on record at the Supreme Court of India. Ms. Ahuja is a leading dispute resolution lawyer. She supervises commercial litigation at the firm and has over 2 decades of experience. She's among the few legal practitioners with comprehensive expertise and specialized knowledge in commercial dispute resolution. Welcome, ma'am. We are really privileged to have you here.
Thank you, Chahat. Thank you so much. Thank you.
Our next speaker is Mr. Karthik Somasundaram. Mr. Somasundaram is a partner with Bharucha and Partners in Mumbai. Mr. Somasundaram is a corporate and commercial litigator with experience of representing in commercial courts and international and domestic arbitrations, institutional and ad hoc. His experience is wide-ranging, including investment and joint venture disputes, lending and borrowing litigation, entertainment and media-related claims, as well as insolvency and bankruptcy proceedings. He has represented banks, financial institutions, and operational creditors in proceedings under the code and has also participated in meetings of Committee of Creditors. Welcome, Karthik, sir. We are truly honored to have you here today.
Thank you, Chahat. Thank you so much.
So before we start, I would like to brief you all that today we have a 45-minute session, and then we will take questions which you can send to us through the chat. I would request everyone to please be on mute for the entire session. So we seem to be all set, and I will now request Ruby ma'am to begin with this legit class. Over to you, ma'am.
Thank you, Chahat. Good evening, everyone, and thank you to all of you who have taken out time to join this. I'm truly honored. So IBC code, this is one code which has been much talked about, if I can use these words. But all of us will agree that it has been one of the most progressive moves of this government. Government has been successful to help the banks and financial institutions to get large outstanding debts cleared and to clean up their balance sheets. This was one problem which banks were suffering, and the earlier enactments, maybe DRT, maybe Surface I Act, were not helpful to the level it was expected out of them. So as I said, IBC code is an act which is appreciated and criticized in equal proportion. But this code, according to me, even for its worst critics, have not been able to meet this argument where the banks come and say that it has helped us to achieve what we always wanted to do. It has helped companies to avoid liquidation. The assets could be protected. We know large steel companies, jute mills, etc. People have been able to save them into going into liquidation. We all know liquidation has its own very, very cascading effects, not only on the promoter, the banks, on employees, on workmen, and so on and so forth. So before I start, I also want to give you some numbers, which will be very interesting. I was quite actually pleased when I read about this. So the IBBI chairman in a recent interview has said that till December 2019, this code helped approximately 190 companies were rescued under this code. The realizable value of 200 of the asset was approximately 207%. So I think this code has done a lot of good work. Though the ride has not been smooth, we all know about that. It has had its own hiccups, but government has stepped in time to time to allow this code to work and to iron out the creases. Even the validity of this code was challenged on nothing else but on the virus as well. But however, that the petitioners could not sustain that challenge. Unfortunately, I will say the amendments which have happened in this code from time to time have happened in a very piecemeal manner. Now, what was the reason why government couldn't do it at one go? Why we couldn't come up with a robust act? Maybe it's a debate for another day. But today, again, there another amendment and another debate, slightly different. The question is that this amendment, which has come now in June 2020, was there a need for amendment which it wants to achieve? So we all know that we are right now, in very acute circumstances. COVID has hit India, COVID has hit the world. It has not only affected human life, but it has affected finance, business, markets. Nothing is happening. It looks as though we all know the world has come to a standstill. So when the first lockdown was announced by our Prime Minister, there was much hue and cry from the business and financial world. Everybody said that government must step in and give some financial packages, stimulus packages, tax concession, tax holidays. There has been a talk that the government is going to come up with another code for micro and small scale enterprises. So this amendment, in fact, has come as part of a financial package on behalf of the government. As we know, the first amendment happened by way of a notification where now the bar has gone, the threshold is of 1 crore. Now, the second is, as we all loosely call it, suspension of IBC proceedings. Before I discuss whether it is right or wrong, or will it work or will it not, let me just give 1 minute and explain you what the amendment says. So by way of amendment, section 10A has been inserted in the code, we all know. And now, if a default happens from 25th March till 25th September, as of now, no insolvency application will lie. Whether no financial creditor, no operational creditor can take an enterprise or a company under insolvency to court. And by the way, the proviso makes situation, according to me, worse. That the default which has been committed during this time, no insolvency will ever lie on that. That is what the proviso says. So how will this work, and will it work? Now, if you will read the section, you will find that there are no bases, there are no conditions attached to it. It is a blanket suspension. So the amendment does not take into consideration, according to me, two major distinctions, and that will be a reason this will not work. Let me go step by step. The first is, the amendment makes no distinction whether the default is intentional, willful, or whether the default in payment by an enterprise or a company has happened because of the financial distress because of the COVID situation. I'll give you an example maybe to make it good. Suppose there is a contractor who signs a contract in November 2018 with a company to make 3 office towers in Gurgaon. So the office towers constructed, completed, interiors done on 28th February 2020. So we have gone according to the timelines. Nobody is arguing here that the contractor has not been able to meet the timeline. We all know, and typically in construction contracts, what happens that accounts are reconciled. There are various reports by architects, interior designers, vendors. You give the report, all is fine, and then you get maybe your last tranche. So under the contract, let's suppose by 1st March, the reports were to be signed. Now reports are signed, everything is good. Nobody has objected to the work, or nobody has said that the contractor has not been able to perform the obligations under the contract. But the contract says that the 4th or the last tranche of payment will happen on 30th March. So where are we? The obligation to pay arises on 28th February when the reports are signed. When the company says, yes, the buildings are in order, everything is in order, interiors are done, we have no objection. But on 30th March, company does not pay. Under what circumstance can anybody argue that this is a COVID-related default? In my view, it is not a COVID-related default. It is a willful and intentional default. That company knew that the time has come to pay. If there was no lockdown, if there was no COVID, if there was no suspension, company had to pay on 30th March. If company doesn't pay on 30th March, contractor will be well within his right to take it to court. So what is the difference here? There is an intentional default. Nobody will be able to check now that intentional default. Maybe the wisdom would have been if there was a provisor which you would have said that you can take such defaults to court or file an insolvency application before the tribunal, but the court or the tribunal will first give a finding as to whether the default has occurred because of the COVID situation, whether it is a genuine default or not. My critics will argue that this will take a lot of time. Be that as it may, let it take time, but it will be better to create a situation where everything comes to a standstill. So the second distinction which I was trying to make was that there is a thing you call where you become obliged to pay. In my example, which I gave you people earlier, you become obliged to pay on the day when the report was signed. On that day, you become obliged to pay. It's only the due date is on 30th March, which now you will not pay because there is no fear. What happens in situations like this? Let's presume for a minute that this is an ideal thing to do. You know, the company may not be able to pay this money. Why should this company be brought into insolvency? We all have to understand that business doesn't work in isolation. Business work, everything is dependent on each other. Such defaults, when they happen, there is a rippling effect. The rippling effect will be that when a company will default, that contractor will also be in trouble. So what has happened? The contractor in its financial and business projection has made sufficient adjustment for this expected payment, this expected fee. But now that fee will not come, now that payment will not come. What happens? That contractor will default on his obligations. He also has to complete his obligations. He also has to pay his vendor. He also has to pay third parties. He also has to pay workmen. He also have to pay his employees. Yes, true. Nobody will be able to take that contractor also under insolvency. But you're creating a situation where in a case like this, you are bringing a company on the verge of insolvency. Does this rippling effect stop here? It does not stop here. It keeps on continuing. The third party will also not get its payment. So what I'm trying to say is that rather than having a complete blanket suspension, the wisdom demanded that there should have been an application of a judicial mind to see a default. Now there will be a situation where companies will feel it is okay to delay. There is no fear. But this is, according to me, also you are creating a false sense of security. What is this false sense of security? This also I would like to just cover a little bit. This false sense of security which you create is that after a little while, when this suspension will go away, we all hope we'll be able to come out of this COVID one day or the other. Then this suspension will create a situation where the cash flows have not been good. Nobody has been able to make any money, but the default and the repercussion of the default will be faced by that company once the suspension is over. So what are you doing? You are delaying the inevitable. The situation will be there. You will have to pay, but it is just that you may get a benefit of 6 months, 7 months, but again, there will be another default and you will have to pay. So you are pushing the inevitable. What happens when you push the inevitable? That you also defeat another objective of the code, which was the speedy resolution process. So there are many, if you leave an example which I gave you of this company, now there will be many companies which are beyond redemption, if I may call them. They're already not been able to pay their debt. They have been defaulting. And a bank or an FI knows that this company, the only way to revive this company out of this is if you take it through the route of insolvency. The moment you stop everything for 1 year, what you're creating a ballooning of liabilities in the balance sheet of this company. The liabilities will keep on doubling up, and this company will never be able to meet them. So you have not even taken into account that distinction. There will be, when banks do their analysis as to whether this company will be able to pay or not, now they will have to wait for this suspension to go away before you take this company. And what will happen once this suspension is lifted, if I may call it? What will happen is this, and it will be a bizarre situation. Companies will be flooded with default notices. There'll be too many default notices. How many companies will be able to come out of it, even if they undergo resolution process after the suspension? Only time will tell, but I am not hopeful. And I'll tell you why. See, the market which will be there after this period or after COVID, we all know will be a highly depressed market for at least 2 to 3 years, according to the experts. It is not going to be a seller's market. It will be a buyer market. Think about a situation where, a company manufacturing steel is at all times low. Automobile sector has no business. Let's presume these companies are put up under resolution process after March 2021, and you invite bids for them. The market will be flooded. The entrepreneurs will find it difficult to find a buyer who can even give them basic half recovery of their assets. It's not going to happen. So whether delaying this whole process will help anything, I don't see that. I do not see that, and it certainly delays the entire process. See, it is very important that companies undergo a resolution process as an ongoing concern. If a company doesn't go under a resolution process as an ongoing concern, it doesn't fetch anything from the market. We have seen that. So if you allow the companies to suffer under the burden of its liabilities, you don't allow them to go into their debt restructuring mode, you don't allow banks to bring them out of it, help them, then what happens? Things stay as they are? No, things become worse. You wanted to give a financial package in a form of this sort of a suspension. By all means, please do. But it should serve the purpose for which it was enacted. It should have been given to people who were not able to sustain because of COVID-related situations. And I can tell you many sectors who would have been able to prove to court, entertainment, amusement park, hotels. We all know that. people in media. They will not be able to sustain. And those were the cases where you could have said it is a COVID-induced default. It is not an intentional default. I'll give you a second example as to how this suspension will be misused, if I may say. Let's presume two people sign a contract on 30th of March. 30th of March for supply of goods. Supply of maybe apples. Okay. Now, on 10th April, the supply is done by the vendor. Apples are given. On 15th of April, the payment is default. There is a default in payment. You cannot take them to insolvency. The person who entered into a contract on 10th of April knew very well that this contract has been entered in a depressed market. Situation is not good. But he knowingly enters into the contract because there is no fear to pay. There is no fear to pay. He knows that if he defaults, the other person cannot even take him to insolvency. So what is left for you now to do? You're left to file a civil suit. That is all which will be done now. So if you don't take into consideration these minor points and allow things to function as they are by giving these blanket, this is not a tax holiday which you give to a company to set up a unit in a backward area in Northeast. Sorry, I mean, I'm just giving an example, or maybe down south, or maybe down north, somewhere where the access is difficult and it's a backward area, and you have given a tax holiday, which is there also. You'd never give blanket tax holidays. Tax holidays are also connected to the objectives. You're supposed to manufacture. You're supposed to employ people from that area. You're supposed to sometimes export that much percentage to get foreign currency in the country. So even a tax holiday is also connected. Here, what you do, you make it a free ride. Free ride, if you have defaulted, the contracts can be entered. There is no bar in entering the contract because that is a private arrangement between two people. But what happens once the default happens? That person is left high and dry to do nothing. So a judicial application of mind was very important so that it could not be misused. And if government really wanted to help, I know I'm running out of time, I'll take 5 minutes, then I do not understand as to why there is a bar on voluntary insolvency processes. For the life of me, I have not been able to understand. It's okay, you say, if I buy your argument that you do not want a financial creditor to initiate insolvency, you do not want an operational creditor, very well. But suppose a promoter who's realizing that he's going to default on its debt obligations time and again and wants a restructuring. Why do you want to throw that company into liquidation? Because under your amended section 10A, even a voluntary insolvency application does not lie. So if a promoter feels that he has enough asset, his own guarantees are at stake, he has enough assets, he has enough, and right now it is a going concern, he'll be able to revive that. He may not be able to revive that, but his enterprise, what he has built, can be revived, his asset can be revived through going through a bidding process, going through the resolution process. You have stopped that also. So just to, if I may say once again, that if you don't allow voluntary insolvency process, if you don't allow banks to undergo the resolution processes where the banks know very well that these companies are without redemption, why are they being asked to wait for 1 year? After 1 year, the market which will face the markets which these companies will face will be worse than what they are facing today. It is not going to be, the things are not going to be that easy, that the resolution will become easy. What happens, we all know under the code, if the companies can't be revived through the process? The answer is liquidation. So what are you achieving with this? You're delaying the resolution process. You're increasing an intentional default because you know there is no fear. You're creating a false sense of security. It is not that the defaults will go away. Defaults will stay. Defaults will happen. Once the suspension is over, companies will be flooded with default notices. You know, somebody once, and I think that's which comes to my mind is that a stitch in time saves nine. In my view, it is a stitch in time. Whether it will save nine or whether it will kill 10, only time will tell. Thank you so much.
Right. Good afternoon, everyone. Thank you, Ruby. I mean, that was really enlightening. And yes, I think one of those instances where I think the co-panelists agree on a certain point of view. And I think this is one of those rare occasions. I think we both are on the same page. So I'll try and avoid reading and speaking again about what Ruby has already sort of shared with us, and that has been very helpful. It sort of lays that background for all of us. But before I start, I hope thank you all of you for joining us, and Karan and Request for this opportunity and allowing me to share this forum with Ruby, and that's a privilege for me, that in itself. Thank you for this opportunity. I hope everyone who's joined us is well and safe, and let's just quickly jump into what we are here for. The point that we're discussing today, or we're looking at today, is whether this ordinance, and I assume that all of us are aware of this, but whether this ordinance is excessive or is it meeting the requirement of the current situation that we are all faced with. But before we get there, let me just sort of take a step back and revisit and just sort of refresh on what IBC is and why was it introduced. And when it was introduced back in 2016, it was and it is still considered as a paradigm altering, not just as a legislation on insolvency, but which of course it is, but it did sort of put everything together in one place. But even in its implementation and enforcement, it has been paradigm altering, and as Ruby already pointed out, the government has time and again found the requirement or the need to step in and amend, tweak, or sort of make modifications, issue notifications wherever required, to implement it better. And I think everybody sort of, it's a given that I think the government's coming from the right place. The intent is there. Yes, sometimes the implementation of it, sometimes just unfortunate wording, I think creates a bit of confusion as to what is being achieved. Equally, I think the Supreme Court has been very active in trying to achieve the objective of the court and in enforcing it in that sense. But I think, as with everything, more can be done, and it will be done over a period of time. And as with any kind of change, I think only time will sort of help us judge if it's been a success or a failure. At this point in time, as with anything else, I think we cannot outthink it with certainty. But I think platform like this, where we sort of exchange ideas and discuss, is a small step in sort of evaluating for ourselves. And then maybe as practitioners of the law, we are able to sort of help achieve the objectives that is set. Just to go back again to basics, IBC was never considered as a recovery tool. The code was not meant to be a recovery tool. It was not, in that sense, an alternate to the existing tools, the legal remedies for recovery. Right? And there are two reasons broadly for saying that. First, in it, that the way the scheme of the act itself or the code itself is structured, if a debt is disputed, then it's not, and this is necessarily true for an operational debt for a fact, but if it is disputed, then a proceeding under the IBC, the court will not be sustainable. You would necessarily have to resort to a traditional route of recovery, of dispute adjudication and then recovery. Right? Second, the scheme of the act is aimed and sort of primed in such a way that it is to achieve its objective of resolving or reviving a corporate debtor, right? And which objective is achieved by maximizing the value of the assets, and lastly to sort of promote entrepreneurship and availability of credit in the system, because each time that a company or an enterprise suffer and collapse, there would be that much loss of credit availability, and of course jobs and so on and so forth. So there was a lot of that issue that was faced, is faced, even if a company doesn't today survive and goes into liquidation because it can't be revived, then you will necessarily have these effects as a consequence. And it is to avoid that sort of a scenario that the IBC was structured the way it is. And it's a very evolving thought on that, and as is sort of evident from the number of amendments, and even for the present, the ordinance, the one that we're discussing, it's just sort of. But we'll come back to the second point as to what the objective is. But first, let's look at the ordinance and sort of see really what it is for. And from the recital to the ordinance, there are 2-3 things that are very clear. It's the pandemic that has created uncertainty and stress for businesses across the country for allegedly reasons beyond their control, and that the nationwide lockdown has added to disruption of normal business operations. Right? And the third objective, or the point, or the background to this, is the one that's most interesting. In it, it says that it is in such circumstances of uncertainty that it would be difficult to find adequate number of resolution applicants for distressed or defaulting businesses. So it sort of re-emphasizes the objective of the court, which is to revive companies and revive businesses and enterprises which are stressed, which are in distress. And then the objective is to say that the reason for this ordinance to suspend all proceedings is because there would not be as many resolution applicants who would be interested in coming in and helping revive the company. That's the objective. Just taking a step back, but this is not the first time that the government has reacted to the pandemic in June of 2020. Even way back in March, even before the lockdown was notified, the threshold for defaults that could trigger CIRP proceedings was raised to 1 crore from 1 lakh, which was a very commendable sort of an effort, I think, but it was largely aimed at protecting MSMEs, because they would largely fall within that sort of bracket, who would default on these smaller amounts. And in a scenario where cash flows would have necessarily dried up, MSMEs would come under threat immediately. So it's to protect the MSMEs that the threshold was increased way back in March of 2020. Also, the other step that the government took on the side, and through the RBI, that is, and that benefit has been passed on, is that banks and financial institutions have given an option to their borrowers in deferring their installment payments if they so choose. The interest obligation would of course continue, but it would not be a penal interest on default, it would be a regular interest on installments that they would be paying. This benefit was initially for a period of 3 months, and thereafter it was extended for a further period of 3 months. And I think they might resort to extending it if the need so arises. Right? In this background, let's just come back to the ordinance again. The finance minister she sort of confirmed speculations which will arrive in somewhere in mid of May that IBC would be amended. And as Ruby pointed out already, this was projected as part of the COVID-19 relief package, which was announced by the Prime Minister in mid-May, just earlier in the week. He'd announced, and then it was followed by about 5 days of sort of detailing, which the Finance Minister and the Minister for State for Finance sort of debriefed and sort of spoke about in some detail over a period of 5 days. So I think in the press conference of either the 16th or the 17th of May, the Finance Minister basically said, in relation to this particular ordinance and this amendment, that debts relating to COVID and lockdown would be excluded from defaults. Right? She stated that that's a step that they were taking, but then she clarified that by saying that any indebtedness that would be incurred by companies because of COVID would not be included in the category of default. And it sort of felt, for onlookers sort of who heard that and read about it the next day, that as so the amendment would be brought about to the definition of default under the Act, and that this particular period, any defaults during this particular period would probably be, taken away from the scope of IBC, and maybe that would have achieved the objective as well. But let's just not get ahead of ourselves. But that was one thing she said. She also said that no fresh insolvency proceedings would be initiated up to a period of 1 year. And she said, and the reason that the finance minister mentioned that this sort of a amendment would be brought about was because even if the lockdown was lifted, immediately thereafter one cannot be sure how much business would be restored. And that's what Ruby just mentioned, saying that you don't know how much business is going to be restored immediately. Therefore, she said that for a period of 1 year, there would be no fresh insolvency proceedings, and they would then continue that, sort of relook that if required. One other bit that sort of came from the earlier notification of March was to say that there would be, for MSMEs, there would be a special insolvency framework that would be notified under Section 248 of the Code. And she sort of repeated the fact that the threshold for IBC initiating IBC proceedings would be raised from 1 lakh to 1 crore, and sort of to take care of it. That was a background in which, rather that was a press conference, and we've had to wait for about maybe 2 weeks for the ordinance to see thereafter, because we thought it would be fairly immediate, but it took about close to 2 weeks or a little over 2 weeks for this ordinance to be promulgated. And Section 10A, two sections were inserted. Section 10A was inserted, and my reading of it, it has 3 parts. There is that operative part of that section. There is a proviso and an explanation. And if I could just quickly jump to what that operative part of that section and the proviso reads first, and then I'll take you to sort of what I think on it. It reads as saying, notwithstanding anything contained in 7, 9, and 10, which is essentially, petitions by financial creditors for Section 7, 9 by operational creditors, and 10, which is that corporate debtors suo motu on their own reach out to the NCLT to try and commence CIRP proceedings, should the need so arise for them to get themselves into that process. That those applications and those proceedings would not be initiated or not be filed for any default arising on or after 25th of March for a period of 6 months or for a period of 1 year, whichever they were going to then notify. And the proviso then said that no application shall be filed at all for this insolvency resolution process of a corporate debtor for the said default occurring during the said period. It shall never be filed. So there was that, which is the bit that Ruby mentioned, saying that it was that blanket or that waving of the stick for all scenarios, irrespective of what happened or why the default happened for that during this lockdown period. Nothing would ever be categorized as a default for the purposes of IBC, of course, right? And of course, thereafter, in case of defaults, as in the necessary corollary to that would be for defaults, which happened either prior or subsequent to that, you could have those proceedings. That was not a problem at all. Therefore, according to the objective, at least what the finance minister mentioned, the default during the lockdown period would not be default for the purposes of IBC. And by saying that no CIRP for 6 or 9 or for a year, this sort of objective would be achieved for any defaults that happened after 25th of March 2020. Right? But I think, as I mentioned earlier, the same objective could possibly have been easily achieved, and with sort of avoiding any further complications, if you could have said that any defaults during this lockdown period, if they had been included, rather excluded from the default definition, we could have achieved the same objective. This is going back to the ordinance. There was this explanation which is then included for just clarity purposes to Section 10A, which just says that that provisions of this 10A would not apply to any defaults committed prior to 25th March. So that was just fairly simple. It was stating the obvious, given the way that the operative part of the section and the proviso were already worded in any case. one bit that sort of came up, and when I was reading this and I was thinking through this, and equally which I think the NCLT Calcutta and I think Delhi had already considered with respect to the notification of March 2020 over the increase of the trigger for the default under the proceedings. They had said that the operation of that section or that notification would be prospective, of course, and it would not be for any defaults that had been committed prior to that notification. Whereas in the way this particular section is worded, the protection of initiation will only be in respect of defaults committed during the lockdown and not for any prior or after. The ordinance in that sense will have a retrospective effect, but will be applicable prospectively from that date, in the sense that if any application was filed after 25th of March for defaults, then those petitions would be rejected, or you couldn't sort of even file it. But any defaults prior to that, prior to 25th March, but if those applications were filed after 25th of March, those would be maintainable. So in that sense, there is that slight distinction to be made, that it does not ban filing of any insolvency proceedings under 7, 9 or 10 during this lockdown period entirely. It is only if the default falls within that period that there is really, in that sense, a ban or a hold back against filing or admission of any of those proceedings. But I think, although that clarity is there, I think that clarity is absolutely only, to my mind, only in respect of an operational debt where failure to pay is necessarily on a demand which is made, and only if the demand is not honored is it a default. So any demand made, let's say around this period, and there is no payment of that, then there is a default, but you cannot necessarily approach the NCLT. But I think that the clarity is only for an operational debt. When it comes to financial debt, I think we might still see some litigation where usually the repayment obligation is in installments. And if in case there is a default of any of the installment, and let's assume that there is a default in the repayment of an installment prior to 25th March 2020, it could, and as most financing documents will have, there would be an obligation or a right for the banks for demanding an accelerated repayment of the entire facility. And in case of such a default, you might also have cross defaults vis-a-vis other lenders and other facilities. So we'll have to see what happens, and if there are litigations that evolve around that. Let's say there's a default before 25th March, and the banks may or may not have called out that default, or may not have recalled that facility. What happens in those litigations? Whether those defaults would necessarily accelerate all repayments or not is something that we'll see, and those would necessarily be determinant on those peculiar set of facts and circumstances that would sort of evolve in those disputes. Right? Just before I continue to the next section, which is also inserted to section 66, I just wanted to examine this, and I did this amendment against the objective of the court, this amendment through the ordinance by inserting 10A. But I touched it and I sort of ran it against the original objective of the court. The original objective, as I mentioned earlier, was that it is not a recovery procedure. It was to maximize value of distressed enterprises and businesses. And if such a business could be rescued, then all the better. That would just be the best thing that can happen for all stakeholders involved, not just lenders and the promoters, but for employees, other businesses which are dependent on this business, so on and so forth. And the one sort of tool available to promoters of suffering enterprises, or where enterprises with chips were down, was through the moratorium that those companies enjoyed, those businesses enjoyed against legal proceedings or distress proceedings for recovery under section 14 of the court in case CIRP was initiated against them. Now, this is a benefit that was available to all sort of proceedings, no matter whether it was a financial debt claim or an operational one, or under section 10, the promoters themselves sort of reached out and tried to initiate proceedings for restructuring of the debt, whichever way it was. This tool was there, this moratorium, this umbrella sort of protection was there for all sorts of debts and distress for distressed companies. Now, and that is the only way that the value in a company could be secured and protected and sort of held almost intact for a certain period of time. Earlier on, the time period was 180 days, and now that's been revived. But that is a way to sort of keep the value intact and make it attractive for prospective resolution applicants who are looking at the company to try and rescue it by acquiring it. But now let's look at the ordinance. What the ordinance does is essentially it prohibits or does not permit any company to be inducted into the CIRP process. And crucially, consequently, what it does is it takes away that strongest protection that IBC offered, the code offered, which was that of moratorium. And that will no longer be applicable for, available for companies, whether that default is deliberate or it is by way of a natural consequence of the current circumstances. Now, please just note that the legislation of the ordinance really says that any default in repayment or payment or any obligation is not a default only for the purposes of IBC. In it, that nobody can drag the company to the CIRP process before the NCLT. But necessarily, this will be this will necessarily be a default under all other contracts or legislations or statutes. This will be, for example, identified as a default under the DRT Act of a repayment obligation vis-a-vis a lender or a bank. Equally, for the purposes of a SARFAESI proceeding, this would be a default if a borrower is not able to repay any obligation to repay, or would necessarily be a default or a breach vis-a-vis an operational debtor if he or she or the company has not been able to pay that money back. And therefore, you could still not thwart or avoid legal proceedings for recovery should such a default occur, just because it's not a default under the IBC. And as with many transactions, you would, and if it's an operational debt one claim, or if it was a financial one, you would most likely have corporate guarantees, you would have bank guarantees that are furnished for these transactions, and that is not stayed. So if there is a bank guarantee furnished for, let's say, purchase of certain goods, and for whatever reason the monies can't be paid on account of genuine difficulty, even if we were to assume that, the bank guarantee would be invoked on the default to pay that pay the monies under that contract. So it really doesn't take away that that the defaults under any other contract or other legislations, and these would still continue to be a problem for these companies which are under stress, enterprises which are under stress. And the one bit that could have necessarily protected them for genuine borrowers at least, or debtors, would have been protected was through the moratorium process, which umbrella that protection would have been available for all of them. But now, because of the way Section 10A is worded and inserted, it's not available for anybody. And as Ruby mentioned already, this is necessarily going to result in a dip in the value of the enterprise. And it's only a matter of time when it is called out. And because this is not sort of, in that sense, not a default again under any other contract or under other legislations, you will simultaneously have legal proceedings which will just come in to try and recover their monies during this time, and they will be aggressive because in that sense liquidity is dry, the cash flows are affected, and this will necessarily rip apart the enterprise and will necessarily cause that stress to a company which is already under distress in that sense. Just continuing on that sort of thought. So this is, I think, the biggest benefit of the IBC3 taken away because of Section 10A, insertion of Section 10A. The other issue that sort of evolves as a consequence of saying that no CIRP proceedings can be inserted is that the the objective which was there to replace management and which was originally under the code, that if a company is admitted into the resolution process, the management would be sort of replaced. The promoters would be moved out of operations. There would be a professional the IRP would take over and have a professional promoter management in place and try and run the company for a certain period of time before it is offloaded onto an interested resolution professional. That objective is now lost or can't be achieved because let's say there was a mischievous promoter, he or she or they will continue to remain in operation of a company that is necessarily stressed and will not allow genuine stakeholders to try and rescue that enterprise. And this insertion of 10A completely disregards that thought process which was introduced through section 29A, where promoters and persons acting in concert or who had close ties with the promoters were not allowed to be resolution applicants for companies through the CIRP process. So the resolution applicants could not be these persons. But that objective, which was the insertion of 29A, was to achieve that particular objective, which to my mind again is a necessarily ignored consequence by insertion of 10A, and it lets these promoters continue to be in management. And just going back to sort of the objective of the ordinance, and it said that the resolution applicants may not be forthcoming on account of the current sort of crisis that is necessarily surrounded. I think the easiest way or the best way that issue could have been resolved was if the CIRP process timeline, which is presently in place, that could have been extended, and that would have necessarily achieved the intent of that ordinance, which is to help struggling businesses find rescuers or resolution applicants eventually over a period of time when things sort of improve. In that sense, I think we appear to have thrown out the baby along with the bath water, and I think we've done to sort of address this. We seem to have done a little more than what was originally intended. Although the objective in itself, I think, was fairly noble, but I think there is an overreach. I think maybe I'm a little too harsh, but I think that the strongest sort of weapon in the armory, which is necessarily section 14, that has been completely taken away because of this 10A, and I think that sort of completely kills the strongest portion for the IBC. But I think it's too early to sort of make any sort of a qualitative assessment, and I think that will necessarily come over a period of time. I mean, it's sort of wait and see. I know I'm running out of time, but I'll quickly just, not more than 5 minutes, I promise, but I'll quickly just sort of take you to the second section that was inserted, which is a subsection was inserted to section 66 of the code, and section 66 of the code is titled as fraudulent or wrongful trading. Essentially, it's a concept borrowed from the UK legislation on insolvency and other legislations in Australia and a few other jurisdictions. But essentially the idea is this, that if a director, and in those jurisdictions, not in India, but in UK and in those other jurisdictions, if a director continues to trade a business while it is technically insolvent already, they would be liable for wrongful trading if that business ultimately enters administration or insolvency liquidation proceedings. And by continuing to trade, the net deficiency, if it increases and creditors sort of lose more so the liability that would fall on the directors, because directors would necessarily during that period, during that stress period, have to decide whether they were going to take additional loans to try and save the business, and whether that was a correct call or not is something that was up for examination in case of those companies not eventually surviving. And there is a definition provided in each of those statutes as to when they will need to sort of decide that they will have to take the company into liquidation. And the obligation under each of those statutes is on the board of directors. They have to decide for themselves. They should not wait for creditors, lenders to sort of come and drag them to proceedings. They should be in a position, because they are in that position, they should necessarily make that call as repositories of interest of other stakeholders to take the company into these resolution processes if they should sort of start to slip down the balance sheet. Right? Uh, and in that sense, the way those legislations are worded, the liability, the way it is cast, is that it doesn't require a deliberate wrongdoing at all on the part of the directors, but it needs to have been a qualitative assessment of the situation. So to just sort of draw a comparison, under a law of tort, we would have sort of, I think, called this as a strict or a absolute liability on the directors, and they do not then have an option to shy away from taking the company to these resolution proceedings. But that kind of absolute liability on the directors and on the promoters and on the management is not in there under the Indian code, under the IBC. Right? The way Section 66 reads, and I'm sort of running out of time, so I'll not read it out to you. But basically, the way it is structured is that once the company is admitted into CIRP, if the resolution professional finds that the business was carried on with an intent to, despite the company being in negative, if it was carried on to defraud creditors for any fraudulent purpose, then the liability would be affixed on those directors and persons operating the company, and they would be required to make contributions to the assets of the corporate debtor while it is in resolution. Right? But this is so that the resolution applicant who would be looking at the company might find it interesting to come and bid and make an application for acquiring the company. But again, the way that section is worded is that the standard of proof is extremely steep, and we all know that IBC in that sense is a summary proceeding, and for you to prove intent, that somebody necessarily intended to run the company into the ground, or they were operating it with some other nefarious sort of intent, is something that would require a trial and sort of establishing the whole process, and which is not possible through IBC. Right? And it's next to impossible to pin it down on a mischievous promoter with absolute certainty if that is what they were looking to sort of do. So in this sort of background, and because in that sense, the 66 is not as primed or as strong as the legislation the similar aspect with other counterpart countries, let's look at the new subsection that's inserted. The new subsection virtually at this moment, as an extension of stopping all new filings of insolvency proceedings, essentially gives a promoters and the management a get out of jail card, if you want to call it that in monopoly terms, right? And but the funny bit is they don't even have to land up in the jail to exercise that card. What Section 66 does, 66.3 now, the new one that is inserted, it basically says is that no application shall be filed by a resolution professional in respect of defaults which have happened during this period, during this lockdown period. So essentially, the promoters can get away with it, and there would be no liability on them at any given point in time in the future. Okay. I just sort of took that and I compared it with the help of one of my colleagues, with the position or the legislation that other countries have introduced on this, and this is in that sense what I mentioned already is a fraudulent or a wrongful trading, and it's not unique to India as I mentioned. And we came across Australia as one of the countries that have introduced it. It's called the safe harbor for insolvent trading, and there the liability is absolute on the director, that if there is a situation where the company is in absolute red and there is no possibility of reviving it, they have to take it to the CIRP process. If they do not take it, they would be personally liable. So in this situation where companies are necessarily suffering, that this particular obligation is what is suspended. And similarly, this is the same position even in Belgium. And in Germany, on the other hand, there is an obligation that otherwise is the statute prescribes that within 3 weeks of becoming over indebted or becoming insolvent, the directors have to necessarily suo motu on their own go and commence these proceedings. By virtue of the amendment that they've brought about now, that obligation is suspended, and the directors can sort of see through and see what they want to do with it. And just before I continue and tell you what other countries have done, and just to take that point that Ruby made earlier, none of these countries have taken away the right of a corporate debtor to approach the, whichever authority there is, whichever court there is, to try and resolve through a resolution process their debt on their own. It's unique to us that in our effort to sort of, to maybe was viewed as an attempt to necessarily help stressed companies, but in that zeal, we seem to have had that overreach, and we've stopped even people or companies who suo moto sort of want to reach out and start this process. Right? No other company has, no other country has, in that sense, done that. Germany, in fact, has gone, I think, a step ahead, and we found that the German legislation were the best, really, in terms of what they were trying to do to sort of effect a better resolution. They've introduced a deeming fiction as to what constitutes a COVID-19 affected case. They said that if a corporate debtor was positive, was green, and was not insolvent as of 31st December 2019, but thereafter found itself in a position where it was nearly insolvent or was indebted, as they call it, then it would be a COVID-19 affected company or a business, and therefore they would then be able to enjoy the benefits that the legislation was passing. Which ties into the point that Ruby made earlier, that our legislation, on the other hand, doesn't seem to have any sort of criteria as to why the benefit was being passed on, or to who it was being passed on. In that sense, everybody's being painted with the same brush, and everybody's being given the same sort of benefit. The earlier bit, the point that I was making, which is that if what the amendment does is only say that this is not a default for the purposes of IC, but it is necessarily going to be a default under other contracts and other statutes, and nothing is going to stop a secured lender from initiating a SARFACI proceeding or enforcing any pledge or any guarantee that's lying with them. I think a situation like that has been thought through, and the only country that we could find which is sort of thought through for that eventuality was Russia, when on 1st April they sort of declared a moratorium on a whole bunch of things. But one of the things that they said was that the moratoriums would prevent creditors from levying any execution on pledged properties or seize any collaterals, including through out-of-court process, which means that no securitization in an Indian context has, because that has specifically been stopped in Russia. They've sort of thought through that consequence as well, and they wanted to address that. But equally, having said that, they have also overshot the mark in it, that they have specifically said that you cannot have insolvency proceedings or bankruptcy proceedings or enforcement proceedings, even if there was a debt or if there was a default prior to COVID. They just said that no proceedings at all for enforcement of any security or debt. Almost as if lawyers in that country will not have job for or any work for about a year from now, and they are going to be in a lot of stress. But that is Russia, and that is fairly, I think, on one side, I think they went correct, and on the other side, they seem to have overshot the mark significantly. But I think the common thread that we found in all these foreign jurisdictions, and I mentioned this earlier, is that none of them have prohibited suo moto for the companies or the corporate debtors from commencing bankruptcy proceedings on their own resolution. And I think to that extent, the ordinance is definitely excessive. It's an overkill. The concerns that as I mentioned, that the resolution plans will not be forthcoming during this period because of liquidity crunch could have been better addressed, and the easiest way to sort of have doing that and allowing genuine businesses to have the cover of moratorium would have been to say that the CIRP process period would be far greater than 330 days that it currently is in India as a maximum limit. Italy and France have done that to some extent. France has sort of modulated it slightly, saying that any insolvency proceeding necessarily mandated pre sort of discussion period and in an attempt to resolve or structure the repayment between a creditor and a borrower. And that period they have extended. And Italy has gone that step further and said that the resolution process period will be for a far greater than what it currently is in the current circumstances. Uh, with that, I think I just sort of conclude saying, yes, I agree with Ruby that this is excessive. It doesn't, in that sense, there is an application of mine in the sense of the intent, but that has not necessarily converted itself into the legislation or the ordinance. And this insertion, I think, is going to backfire. We'll have to wait and watch, but I think it's probably not the best solution on our plate at the moment. Thank you.
Thank you so much, Karthik sir, and thank you so much, Ruby ma'am. It was indeed an insightful session. Moving to the Q&A session, we had received a lot of questions, but due to time constraint, we had to pick only few, and few of them have already been answered by Ruby ma'am and Karthik sir. So the ones that are lined up, I will take them one by one. So the first question is, Ruby ma'am, with American negativity towards China, do you think India can emerge as the preferred business hub in Asia? Ruby ma'am, you are on mute, I'm sorry.
Can you hear me? Sorry.
Yes, ma'am, you're audible now.
Sorry. No, I was saying, should I say this is out of my syllabus? No. Okay, it's okay. Well, India, if I don't have to be diplomat, I think that's a far cry. We have too many issues right now in India where I feel that business, it will take some time before we become a business hub. The most important is we really need to look into the commercial litigation, the laws as it stands, and the time we spend in litigation. So that maybe that will take another hour, what all we need to do. But I have seen that the very fact that, everything, every small, big project, every clearance can be taken into court by anyone without paying any fee, without being liable for any damage the delay caused, is one prime reason where companies do not want to come in. There are also companies who also don't want to come in, who say that when we want to step out, the one injunction order and we can sit here 20 years. So I think that, it's not, the resources are not a problem. Let me tell you, I also don't believe in this, that infrastructure is a problem. I think infrastructure can be dealt with, but I think we really need to work on our rules, regulations, and also need to bring consistency in law. Inconsistent law is only helpful to lawyers. It doesn't help anybody else. If you see your own IBC Act, it has been amended so many times that there used to be a joke in law firms that by the time you buy this book, this code gets amended. You'll have to buy another book. So, those things, till the time you settle that, I don't think so it can become a business hub in Asia. I won't pitch the case so high.
Thank you, ma'am. Karthik sir, would you like to add something?
Yeah, I don't know whether we are ready to be a business hub. I think we definitely want to be a business hub for sure. Whether this is the opportunity that we take to sort of get there, I don't know. I think in the current circumstances, I think it may be a little difficult. But yeah, I think there is that sort of tool with us in it, that we have the right intent. We seem to have the right sort of people and the mindset and resources to do it. Whether we get around to doing it, I think that's a different question. So have to sort of see that.
Okay, thank you so much. In continuation to that, Karthik sir, do you think that the approach of corporate rescue mechanism has been designed in a balanced way in IBC 2016, including even so many modifications?
Is it in a balanced way, you say?
Yes, sir.
I can tell you from experience that it's a little tedious. It's not the easiest of processes. There are way too many people involved, and maybe so because you have to necessarily hear the concerns of employees, workmen, or operational creditors, financial creditors, of course, having the biggest sort of stake in it. But I think having so many sort of stakeholders in it, in the process at the moment, also sort of results in a situation where the resolution professional and the resolution applicant are sort of dragged and stretched out in multiple directions. And therefore, that necessarily results in a lot of disputes before the resolution plan and the process can be sort of fully implemented. I think that requires a bit of relook. Just to give you an example, we were sort of participating as a firm. We were representing somebody in the resolution process of SR Steel. And at one stage, after the resolution plan was approved the first time around, there were 55 applications challenging that resolution plan before the NCLT in Gujarat. And there was just one bench, and it was completely overwhelmed. And it took about 3 directions, if I'm not mistaken, from the NCLAT before the NCLT could sort of come around to completely disposing it off. And even then, it was not the best sort of efforts put in, and therefore it went through some change at the NCLAT level. But that sort of demonstrated for everybody to see how sort of litigious the process is and how uncertain it is. So I think there is some sort of work that will require to be done definitely to that process. That's a separate subject, though. We'll have to discuss that separately. But I don't think it's the most optimal one at the present moment.
Thank you, sir. Ruby ma'am, would you like to add something on this?
Well, I agree with Karthik. It is a very tedious process for sure. And let me tell you with some sort of an experience that a time comes when a genuine resolution applicant who's standing with money and trying to get a company out of insolvency is ready to walk out, because it is very litigation prone. As I said in the opening today, that this act has been amended in very piecemeal manner. I think there is a time to have a holistic approach towards it. And even if you see, and what brings these cases to court time and again is the whole process of distribution of money. In spite of its amendments, which has happened as late as in August 2019 regarding the section where how the money will be distributed, I still feel there's a lot to do there, because rightly so, you cannot beat that argument. If you take a neutral position that if you owe 1,000 rupees, then how do you get 2 rupees and you're supposed not to question? So those things are there. I think if our legislature looks purely into the distribution issue once again and brings out a holistic approach, things will fall to their place a lot, and there'll be less litigation. Because don't forget, after ArcelorMittal's second judgment by Justice Nariman, the court, the tribunal interference, the adjudicating authorities interference has been highly reduced. So that is a good thing. But still, and COC has been given a lot of power here, but I still feel that much needs to be done, and that's why. But this time consuming and money consuming process it has become. But still, it has still achieved a lot for us. We shouldn't. There are cases of insolvency of Bhushan Steel, SR Steel. I don't know whether Alok Industries finally succeeded or not. I'll have to check that. But there are cases which have been Binani Cement have been successful. So I think we shouldn't criticize it much, but we should iron out the creases, but not in a piece, not in like one square here and one square there.
Okay, thank you so much. The next question is, do you think suspension of proceedings reflects an inability to adjudicate debt disputes during a pandemic, which signals general unpreparedness?
Well, see, before we say that, we'll all have to remember that pandemic is not that world was experienced to deal with it. You still have some experience to deal with a flood. You still have some experience to deal with drought. You have no experience, at least this generations have no experience to deal with this sort of pandemic. So I don't think so. The general unpreparedness was the reason that we won't be able to adjudicate upon them. I think the government wanted to give some sort of, it was a reaction to, satisfy and soothe the market. That market is in a very, very depressed state, and businesses are feeling that we need some help from the government to survive. So, and the logic and the intent is not wrong. Please appreciate that. You can't be bringing enterprises, companies, small enterprises into the brink of insolvency because they could not pay, 3 operational creditors while they are earning no money. There are no sale, there is no business. So the intent is there, but as I said, you need to chalk out the criteria under what circumstances this sort you want to hold the hand. Sometimes you have to hold the hand of needy. You don't have to hold the hand of a person who's ready to jump. So a promoter a company who's doing very well doesn't want to pay. That person doesn't need your help.
Thank you so much, ma'am. The next question is, Karthik sir, how would the NCLT in the new amendment determine deaths as COVID or non-COVID, given that NCLT is not a fact-finding authority?
That is the whole point, as it is. That's what Ruby criticized right at the start, saying that NCLT is not going to do that determination at all. What was required, as she said, it would have been, and there would have been a preferred one, although time-consuming one, would have been a judicial determination of whether it was a COVID-related death or a default or not. Default, sorry, not death or not. But that option has been taken away entirely by this. You cannot have any defaults during this period as part of the insolvency process. But like I mentioned, these would definitely still continue to be defaults under other provisions and contracts, and the consequences will sort of be borne out there. If not IBC, under securitization, under DRT, arbitration, whatever else, suits, whichever way they will be. But for the purposes of IBC, NCLT will not be determining that. NCLT doesn't have the power to do that. That sort of judicial determination will not be done by virtue of 10A.
Thank you, sir. The next question is, would the suspension of provisions of IBC be detrimental to creditors? How can creditors' rights be further protected? Ruby ma'am, would you like to answer this?
Yes, I have answered it. Yes, their rights are protected. I won't say that their rights have been taken away, but they'll have to wait to exercise those rights. Now, whether that exercise of rights at that time will you succeed, or will you be able to salvage the situation, that I don't know. That time will tell what sort of, as I told you, what sort of markets will you get, whether there'll be enough, applicants in the market. But the creditors' rights are protected here. Nobody is saying that if as Karthik rightly said, that, in various bank cases and loan agreements, the default may be now, but the promise has been made earlier. So there will still to be decided what is a default there, whether it is between 25th March to September or not. So the rights are protected. Creditors will have their rights, but they'll have to wait to exercise them. So there's a suspension. That is why the word is used, suspension. Don't do it now, do it later. Question is, can you wait? And if you wait, how detrimental is that wait to you?
Thank you so much, ma'am. Karthik sir, would you like to add something?
Absolutely. I think what we covered that, it's right. I mean, it's not that the rights are taken away entirely, it's suspended for the time being. And equally, I think if we sort of keep this at the back of our minds, that IBC is not a recovery statute for enforcing your contracts and recovering monies, you will realize that that's in fact not happening. There is no right taken away really. But yes, if you were to see that the right or the interest would be best served if the maximum value was obtainable through a resolution process, and that would better benefit all creditors. Yes, that seems to have been affected without necessarily affecting their right, but their remedy in that sense to get a better value out of a distressed company seems to have been affected for now. And like we mentioned, if there is no market, and there will not be a market, because you will not suddenly be able to find cash flow and liquidity in the market overnight. It's not going to happen. Right? This is a long process. We are going to suffer this for a while, and in that sense, the remedy which was there to get a better value, that's definitely lost. But the right itself is not lost.
Okay, thank you so much. Ruby ma'am and so we have a lot of questions. So, and the time is up. There is a time crunch. So do you want me to take 2 or 3 more questions?
You could, well, my apologies. I realized that I overshot significantly.
Chahat, I can take one more question, then I have to leave. So I can take one more question if you want.
Okay, thank you so much, ma'am. So I'll just put forth one more question. What are your views on pre-package insolvency? Do you think India should introduce pre-pack when we are anticipating insolvencies are bound to increase?
Well, pre-package insolvency, I don't think so. The time has come. Right now, India is prepared for pre-package insolvency. I am not in favor of pre-package insolvency. It will take some time before we really get ready for it. Right now, as you said, even a pre-package insolvency will not help you in this situation where there is no liquidity, there is a cash crunch, people are not ready, there is no, you can't even restructure your debt. So how does the pre-package insolvency help in this situation? I don't think so. It will help right now.
Thank you so much, ma'am. Karthik sir, do you have any views on
Yeah,
this?
I think pre-pack is not as simple as it sounds, right? Pre-pack essentially takes into consideration interests of all the stakeholders. It's not just one creditor whose interest is sort of addressed through that pre-pack. Uh, we have a scenario where the courts are not able to enforce, and there is litigation as you mentioned, because the distribution process is so skewed, and the NCLT cannot interfere, but the COC has a significant hand and say in what the payout is likely going to be for them as opposed to the others. And if it's not proportional, and it will never be proportional, but if it's going to be significantly skewed in favor of the financial creditors, other stakeholders will fight. And if this is a process which is and this is something that's happening under the supervision of the NCLT, repacks are going to happen before you even land up in the NCLT. And you will never have a scenario, you will maybe not never, but you'll have the most difficult job on hand, and the resolution professional who would have been appointed, you have the most difficult job on hand trying to get everybody to agree to it. And I think if you get everybody to agree to it, you could very well also do an out of the court sort of a scenario settlement or an arrangement put in place. We may not necessarily require impact. So the implementation of it and sort of the structuring of it, I think India is not maybe a mature market for that. We will try to we'll still have to try and strengthen our other processes in place before we get down to that.
And Chahat, one last thing, for pre-package insolvency, you'll also have to look into the Contract Act. I'm not sure. Somebody will have to look whether it will be against your Contract Act or not. So that, because our Contract Act is also quite, outdated, if I may say. So I don't think so. Pre-package insolvency in this scenario can work for India.
Thank you so much, ma'am. Whatever questions are remaining answered, we'll put it to our experts and get back to our participants. Thank you so much, Ruby ma'am and Karthik sir, for being with us today and taking this legit class, which was quite a knowledgeable one. It was an honor to have you both.
Thank you so much.
Thank you. Thank you, Chahat. Thank you, Karthik. Thank you, everyone.
Thank you, sir.
Stay safe.
I would also like to thank everyone for participating in today's Legit class. We hope to see you again next time. For recording of this Legit class, you can subscribe to our Legit Quest YouTube channel. Thank you all and have a great weekend. Bye.